Hi and welcome. I am your host, Larry DeMarco. A friend of mine introduced me to a TED Talk, The Psychology of Evil, given by a famous psychologist, Dr. Phil Zombardo. The presentation discussed prison guards and how the lack of oversight can lead to the abuse of prisoners and evil behavior. He includes his TED Talk by encouraging listeners to engage in heroic behavior as an antidote to evil. When watching Zombardo's TED Talk, I saw a striking similarity to the court system and the judiciary, particularly family court, where judges have absolute power, almost no oversight, and they similarly abuse power, as did the prisoners in Zombardo's TED Talk. In this video, I will discuss the TED Talk, Zombardo's research about how absolute power can tempt good people into evil behavior, and discuss the relevance of Zombardo's talk to the court system. I'll also present solutions to the abuses in the court system and the need for the modern-day hero to put those solutions into effect. His entire premise is that power is abused not by people who are inherently evil, but by faulty systems. He begins with the premise that people aren't necessarily good or bad, but a combination of both. Dr. Jekyll and Mr. Hyde. People are influenced by the Lucifer effect, which Zombardo defines as power that tempts ordinary, regular people to engage in bad behavior. The human mind has the ability to choose to behave badly or behave well, to commit atrocities or become heroes. He illustrates this Lucifer effect with 3 examples. The first example he gave was American soldiers who abused Iraqi prisoners in Abu Ghraib. You might remember this from being in the news and seeing graphic pictures. A second example was an electric shock experiment designed to test whether current circumstances existed for a second Holocaust. The third example he gave was from the Stanford Prison Study, Zombardo's own experiment. For the first example, Zombardo was retained as an expert witness to defend one of the soldiers at that Iraqi prison. Pictures were taken by other American soldiers and were given to the media, and it exposed extreme human rights violations against prisoners accused of having terrorist connections. Zombardo deduced that the human rights abuses happened because the government gave those prison guards absolute power to break the will of prisoners for interrogation. His hypothesis is American soldiers are usually good. They're not a bunch of bad apples. It was the barrel that was bad, meaning the system that gave the soldiers absolute power with no oversight or accountability. The United States court system is another situation that gives judges absolute power without any oversight, accountability, or transparency, and therefore facilitates judicial abuse of power or evil behavior. So let's review a second example. Stanley Milgram, another famous psychologist, tested whether the Holocaust could happen again. He showed that people could easily be coerced into behaving badly. He ran an experiment where he would give people the power to shock innocent strangers with intense, painful electricity. The experiment created the illusion of testing and improving people's memory. He randomly divided a group of 1,000 people into learners and teachers. The learner gets strapped to electricity, and the teacher gets a button in a different room and watches the learner through a window. The teacher's job is to give the student material to learn and questions to test him. You get the answer right, give the student a reward. Get it wrong, the teacher shocks the student with increasingly powerful volts of electricity in 15-volt increments up to 450 volts. So, as you can imagine, as the electricity intensified, the student began screaming and pleading for mercy and begging for the teacher to stop in horrible agony. The scientist, the one conducting the study, convinces the teacher that the scientist himself will bear all responsibility if anything goes wrong, whereas psychiatrists assume that only 1 in 100, 1% of people could be convinced to press that button of extreme danger. In fact, the vast majority, from between 2/3 and 90% of normal people, would torture a stranger and give that extreme shock. Milgram quantified evil as the willingness of people to blindly obey authority and forsake their own morals. His conclusion: you can tempt the vast majority of normal, regular people into committing evil acts. Zombardo clarifies that most of the time with human behavior, we're acting within institutions, not just as individuals, illustrated by the third example in his TED Talk. Zombardo conducted the Stanford Prison study that illustrated the power of institutions to influence individual behavior. In that experiment, he picked 24 of the healthiest and strongest out of 75 volunteers. He randomly assigned them prisoners and guards. The idea was to put the best in a bad situation. The experiment empowered the guards and dehumanized the prisoners. He gave the guards the symbol of authority and anonymity, dark glasses, uniforms, and billy clubs. And he stripped the prisoners, removed their names, and gave them a number. In 5 days, the Stanford prison guards began to abuse the prisoners just like the soldiers abused the prisoners in Abu Ghraib. 5 prisoners had breakdowns within 36 hours. The abuse was so bad that the study ended after 6 days because it was out of control. Zombardo learned that changing one's appearance makes a difference for influencing behavior. In some cultures, armies paint themselves. In others, soldiers wear masks. Just like army soldiers can be anonymous in uniform, judges put on a black robe. And in some countries, they wear wigs. Here are the top, what Zombardo calls social processes that grease the slippery slope of evil. Mindlessly taking the first small step, dehumanization of others, de-individualization of self, diffusion of personal responsibility, blind obedience to authority, uncritical conformity to group norms, and passive tolerance to evil through inaction or indifference. A system in our society that has the widest reach, most influence, and almost no transparency or accountability is the legal court system, where human rights violations occur with the pounding of a gavel. 200 years ago, it was our founding father, Thomas Jefferson, who criticized the judicial branch of government in a letter. Quote, "You seem to consider judges the ultimate arbiters of all constitutional questions. A very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. Our judges and their power are more dangerous as they're in office for life and not responsible like other are to elective control. Its members would become despots." In addition to having judges serve in judicial office practically for life, their position has also become increasingly political. This sets up judges as pawns of a political system who must answer to their campaign donors, committee people to whom they must seek an endorsement, bar association lawyers who can recommend them as highly qualified, and political bosses who can appoint them as judicial candidates or political appointees. These powerful groups often have contrary interests to the rule of law or the public who the judges swear to protect. The newscast, Democracy Now!, featured an investigative report entitled, "Is Your Judge for Sale?" a trend which has accelerated over the past decade.
A new investigation zeroes in on this year's judicial races, which have drawn unprecedented attention from dark money donors that seek more influence for less money than bankrolling legislative campaigns.
The story's headlined, "Is Your Judge for Sale?" Thanks to Karl Rove and Citizens United, judicial elections have been overtaken by secretive interest groups, nasty ads, and the constant hustle for campaign cash. We're joined by its author, Andy Kroll, senior reporter for Mother Jones Magazine. Welcome back to Democracy Now! Andy, you only have a few minutes. Lay out what you found.
Well, what we've seen is that judicial elections have become another playground for the same kind of business interests and huge spenders and anonymous donors that we're seeing in presidential races and congressional races up and down the ticket. And our judicial elections used to be a more sleepy corner of American politics. And obviously, the dynamic is different if we're electing the arbiters of the law. But times have changed, and Citizens United has really begun to change the landscape in this place.
A nonprofit, Pennsylvania for Modern Courts, discussed the particularly harmful effect that money has on the judicial profession. In the following clip, the speakers focus on appellate judges, but these principles still apply at the local county level.
Judges are different from other public officials. Officials, like governors and legislators, are elected to represent their constituents and follow through on campaign promises. But judges are sworn to decide cases based strictly on the facts and the law. Selecting judges, the same way we select our politicians, is causing big problems.
It costs over $2 million to run for the Pennsylvania Supreme Court. Because of that vast amount of money, the perception to the public is that the judge will be biased in favor of those interest groups and those individuals who have donated heavily to their campaigns.
When people think about courts and the image of a judge in the robes or the image of Lady Justice blindfolded, they want to feel that they can come to courts and no matter who they are, no matter where they come from in the state, no matter their race or their gender or their economic status, that they'll get a fair shake.
Pennsylvanians have many reasons for their frustration with the courts and the desire for change. The problem heard most often about Pennsylvania's courts. 76% of Pennsylvanians believe that judges are influenced by campaign contributions.
A good friend of mine who came to me one day and said, I just had a weird thing happen. I was in court and the judge came in and I turned to my client and I said to him, I don't like this. I don't like the feel of this because the lawyer on the other side was the head of this judge's campaign committee. And that's going to be a bit of a disadvantage for us. And he said, my client thought about it for a minute and said, why weren't you on the committee?
I am very concerned about what it's doing to this country to have partisan election of judges and big money changing hands.
A movie, Divorce Corp, discussed the toxic effect that money has on judges in the domestic relations setting and the near unlimited power that judges have to collect debt.
The attorneys representing my ex-husband were also large campaign contributors to the judge in our case. If you pull the records, you'll find oftentimes that the attorneys who make the largest contributions to the judges tend to win most of their cases. And the judge said, this thing about contributions is as uncomfortable for a judge as any topic you can get on. That's because you folks that are non-lawyers don't contribute to judicial campaigns. And the only way that a judge can run for re-election is to raise money for all those things that cost to get your name before the public. And you know who has the most interest in seeing that done? The lawyers.
And if we read on, he says the lawyers only contribute to good judges. So what does it mean to be a good judge in the eyes of a lawyer? Perhaps it means seeing things their way. Some lawyers even boast that they can control the outcome of a case.
They have it now where $300,000 to $400,000 will guarantee the outcome.
Amazingly, these same judges are also the ones who approve the bills of all the court professionals who work on your case.
We talk about who are the most ferocious or feared collectors, and often you hear things like the IRS, right? On that list, near the top of the list and the most fearsome would be the courts. And the reason is they have a lot of extra legal tools.
In Delaware County, there was a perfect example of the power that the courts can exert on a litigant to collect a debt generated in divorce court. The litigant was imprisoned for 14 years for refusing to pay his debt, similar to a prison term for murder. As you can see, there's no dispute that a judge is one of the most powerful debt collectors in society. So lawyers, businesses, and others use every method in their arsenal to influence them.
And campaign contributions are just one of many incentives that are used to influence judges.
They have a family law section of the Los Angeles County Bar that's very active, that puts on programs. Some judges will sit on that executive committee from time to time. Judges will be in all the programs that they present. You work together with them on panels, on presentations. So there's a lot of contact and communication, and you see these same lawyers all the time.
The law firms have created conferences, all expense-paid trips, and even awards that they give to the judges. And these activities are often sponsored by the same lawyers who present cases to these judges.
The promise of employment for a judge upon his retirement can be the strongest influence.
When a judge goes into retirement, they not only get a generous pension, but they also have the option to continue practicing privately as a judge or as a lawyer. And the law firm's pay is exponentially higher than what they were paid by the government. And unlike other public officials, judges do not have a waiting period between public and private practice. A judge can retire one day, practice as an attorney the next day, and then go back to being a pro tem judge a day later. Amazingly, your opposing attorney could literally have been serving as a judge the day before, having had lunch with the same judge you're sitting in front of today. With all this happening behind the scenes, it begs the question, is anyone actually getting a fair trial?
As I always tell my grandchildren, follow the money, and you'll figure out why people are hurt and who is helped.
Susan Settembrino is a New York lawyer who fights corruption, and she wrote a book and lectures about judicial reform. In a presentation about judicial bias and the political process, she begins her lecture by emphasizing that judges must be independent, and this includes society's ability to criticize the judiciary to bring about reform. Without such judicial oversight, judges become just like the Abu Ghraib and Stanford prison guards who commit horrible human rights violations.
Judicial independence does not mean that we cannot criticize the judiciary. Sandra Day O'Connor has recognized it is good for us to have constructive criticism over the judiciary. That's what brings about true reform.
I think we should keep cash out of the courtrooms.
The system has been corrupted with a gross infusion of money and partisan politics. Judicial candidates no longer need to please the public, only political parties and large donors. And in these partisan times, the public votes for their party, not the candidate, so judges have no incentive to please the public. Donors give money to influence candidates, not altruistic purposes. Susan Settembrino quoted an Alabama Supreme Court justice.
In all other races for public office, contributors would say that they give to campaigns to ensure that candidates are elected who will represent their interests and give them access to the public official when issues arise. Checks and balances. This is the most important aspect we can have. 3 separate functioning independent branches of government to act as checks and balances on one another. But in a politicized court system, these 3 branches are no longer independent. They are beholden to the political machine, the machine where attorneys and where special interest groups and where businesses, that they are funding this machine to ensure their candidates are in office. The governors, the attorney generals, the DAs, the assemblymen, the judges, they're all part of the same machine. So do you think there's any oversight or accountability in that machine?
When a political party controls all 3 branches of government, all critical checks and balances to limit government overreach are eliminated.
And these contributors, the lawyers, the special interest groups, and the businesses may very well come before these judges on multi-million and even billion-dollar cases. Unfortunately, the only people who suffer is the public.
The public suffers because money, special interests, and campaign donors play the strongest role in government, including the judicial branch of government. Settembrino goes on to say that political bar association lawyers are another group that influence the judiciary and enjoy special favors within the court system.
The Bar Association advised the attorneys, do some of the following. Become a delegate to their party's judicial convention. Collect signatures for a judicial candidate. Donate funds to support judicial candidates. I'm quoting, by the way. The Bar Association admitted that the attorney must become known to the people who appoint judicial panels, that most screening panels are active members of the bar or community groups. And this is crucial, that judicial elections are primarily determined de facto at the nomination stage. And the election, well, that's just a formality.
Please note the monumental implications of what Settembrino is saying in this video clip. When one political party is dominant in a county, future judges of the county are selected at the committee person nominating stage. The actual election is merely a formality. She continues about the power of the politically connected lawyer.
These political attorneys can get appointed to all sorts of funded programs, such as the fee dispute program, I'll discuss a little bit later, and say the Law Guardian program, the children's attorneys. Actually, there was a case where a judge in Staten Island was outed for appointing law guardians to these cases, and all of the law guardians that she appointed contributed to her campaign, 100%. And do you think that those law guardians are going to be concerned about advocating zealously for their clients or about pleasing this judge for the next appointment? You know, these political attorneys, they may enjoy lucrative practices in front of these political judges for years. These judges then may retire and go into these political law firms, okay? So it's a cycle here. On the website of certain law firms, they actually list that they have relationships with certain courts, and they list the judges. I found out what it meant to be the attorney who didn't have that relationship, and it wasn't pretty.
There's a collusive relationship between political attorneys and judges that's unfair to any outsider. We've known about corruption and undue influence on judges for over 100 years. But powerful political insiders don't want anti-corruption laws or ethics reform because it would weaken their own political power and control.
Partisan judicial elections are by far the most expensive. Lawyers and business interests account for at least 49% of all contributions. Public confidence. 76% of voters and 26% of state judges believe that campaign contributions influence judicial decisions. 62% of voters, including nearly 90% of African American voters, feel that there are two systems of justice.
The current political system is rigged so that extremely wealthy donors can control elected officials and set up government with unchecked power. The judicial system has little, if any, accountability, so the courts ultimately serve as an arm of the mega corporations and mega wealthy who put the chief judge in office.
This is the chief judge. We may create a concentration of enormous power and funding in the hands of a few politically entrenched, or at least very vulnerable individuals. The chief judge enjoys extraordinary power without any interference, regardless of how dysfunctional or even dangerous the court system under his administration may be. Now, no matter how wonderful you think this man is, no one deserves this much power and this much control over the court system and its multi-billion-dollar funding. Nobody. This creates a political court system that becomes an impenetrable vacuum of enormous power and funding. If you have a problem with the judge, go to the Commission on Judicial Conduct. Don't worry, you'll be heard. You have a problem with integrity in the court, go to the Inspector General. You need a law guardian? Right there. And mental health professionals here, attorney discipline. It's all right here, one-stop shop. Susan Rose Ackerman has detailed how you can use the court system as a political gender and even a criminal enterprise by creating an opaque, overly bureaucratic court system with an incentive for payoffs to cut through the red tapes, by creating bribes to staff, such as clerks and trial judges, can speed up or slow down cases. If pay and working conditions are poor, and they always seem to be, judges and their staff may be relatively easy to corrupt. If top judges are corrupt or politically dependent, they can run a punishment and reward system by transferring or promoting appellate or trial judges. Judges can manipulate assignments of cases to the judges willing to rule in favor of select attorneys. Trial judges can easily manipulate trial procedures in favor of certain attorneys and their clients to ensure certain outcomes. The courts can be used to protect misconduct and even crimes. The disciplinary and the judicial ethics committees can protect attorneys and judges. Fee dispute committees can protect fraudulent billings. Judges can ensure a lack of oversight and accountability. Judicial budgets can be skimmed or redirected. In addition, if the judicial budget is being used to promote offices that target and protect, that's unlawful.
The consequences of a political judiciary are severe and predictable. Settembrino discusses the consequences in detail.
The consequences of a political judiciary. Well, the disciplinary committee can open up false investigations against an attorney. They don't have to have any merit. They just keep it open. They ruin the attorney's career and finances. You can have Political attorneys serving on a fee dispute committee and make fraudulent fee disputes against an attorney. And they can issue fraudulent awards and at the same time protect their own fees. And they get immunity.
The weapon of a prison guard can be the baton, forced solitary confinement, and other humiliating abuse. The weapon of a judge is what Settembrino calls a false order. She explains its destructive power and how it creates a bad system as opposed to bad apples that Zombardo warns against in his TED Talk.
False orders and judgments. This is one of the worst things that we can experience in a courthouse. Every order is a powerful blank canvas. False orders and judgments can easily be created and continue for years. By placing politicians on the bench, decisions become unpredictable and the outcomes can be chaotic and, I believe, dangerous. So what is a false order? When a judge creates rulings that knowingly fabricate, obliterate, and distort the facts and/or controlling law of a case. False orders can protect criminal misconduct, even in the face of overwhelming verifiable evidence. False orders can erase evidence, events, and facts. False orders can extort funds, creating sudden, unwarranted wealth and/or indebtedness. False orders can destroy children, families, the elderly, individuals, and businesses. False orders can put innocent people in jail.
We know we can do better. Any powerful government without checks and balances will create absolute power that corrupts absolutely. One-party rule, whether Democratic domination in cities like Philadelphia or Republican domination in suburban or rural locations like Delaware County, will eventually eliminate constitutional checks and balances in government because all the branches are beholden to the political machine. The influence of money on judicial conduct is particularly horrifying when you consider a judge's near absolute discretion in divorce court.
When you go to divorce court, you'll find that judges can do whatever they want.
There is no law in family court. There's only what the judge wants to do, period.
All kinds of basic mechanisms that exist in the criminal and civil courts in this country don't exist in the family courts. In a family courtroom, the judge dominates the proceeding.
In my world, where there's no jury, you are the decision maker. I'm more comfortable with that.
How much time do you have to devote, would you say, to each case?
On a typical Monday or Tuesday, I would have a calendar of anywhere from 15 to 40 cases.
The average case, in all fairness, is maybe 5 to 10 minutes.
The Court of Appeal in San Diego ruled that actually judges did not have to read the pleadings before they made their rulings. So now it's a local rule. If you want a judge to actually read the pleading, you've got to make a special request beforehand. Not too many people know that.
It's not for the father to decide. It's not for the mother to decide. It's for the judge to decide after the judge has weighed all the factors.
All of us make decisions. You decided what color socks you were going to wear this morning, what you're going to have for lunch. But a judge makes decisions for other people. And you make 100 of those a day. And if you make a bad one, you just make another one.
My father was a lawyer who handled a general practice, and he occasionally would take me to court with him. When I was about 14 or 15, he had a case, and the woman was on the stand, and he's boring in on her, and he's boring in on her, and he says, "And didn't you on July 5th have sexual relations with your husband?" And she breaks down crying and sobbing, and I'm looking at this, and I said, I got to get into this. This is great.
All judges have the same middle name, God.
The Lucifer effect on prison guards with absolute power and no accountability also affects judges. They're in a similar situation and cause similar injuries and rights violations. There's a solution. The solution to corruption in the courts is transparency and accountability. Susan Settembrino first discusses transparency.
What we need, as Professor Susan Rose Ackerman has pointed out, courts must publicize their operation and decision process. Judges must disclose their assets and conflicts of interest. Outsiders like us must be able to find out what is happening in those courthouses. A free media with access to judicial proceedings and documents, along with an active civil society to publicize lapses and work for reform.
The following steps will ensure greater transparency: allowing electronic recordings in courtrooms, measuring judicial performance objectively, and providing more predictable guidelines for disqualification for judicial conflicts of interest. Let's look at all three individually. PA Court Rule 1910 applies to electronic broadcasts in courtrooms. PA allows recordings, but only when both litigants consent, and only for educational purposes. However, the Constitution guarantees a right to a public trial in a criminal case, and the First Amendment presumes a public trial for civil cases as well. Media access is necessary to educate the public, and electronic recordings is a common, accepted instrument of the media and an effective method to achieve transparency. This court rule should be amended to permit recordings at the request of either party, and the footage should be available for appeals and disciplinary proceedings. Second, measure judicial behavior objectively. This principle has already been considered by the American Bar Association. See the link below for more detail. In short, the American Bar Association's message is this: states with elections, like Pennsylvania, government's not allowed to use resources to measure candidates, so the role of evaluating judicial candidates falls on attorney bar associations. So how should judicial behavior be measured? A modern example of how to measure judges and judicial candidates occurs in Philadelphia, where its bar association calls its judicial candidate rating system its crown jewel. The bar association publishes who does the evaluating, the standards used, the criteria for evaluations, and the information considered. An example of how not to rate judicial candidates occurs in Delaware County, where a politically partisan bar favors its own candidates and penalizes the opposing party. For more information, see this link for a video comparing and contrasting judicial bar rating systems. Now that the courts can digitally store data, patterns in judicial decisions can be accurately and efficiently monitored so that society can and should evaluate judicial decision-making trends. This will expose judicial biases and tendencies with greater ease over the course of time. If baseball and other sports can measure professional performance, so can government. Third, provide more predictable guidelines for disqualification for judicial conflicts of interests. A judge's canon of ethics requires a judge to disqualify herself from any proceeding in which the judge's impartiality might reasonably be questioned. Although the disqualification rules give some definite guidelines, they're deliberately vague related to financial interests and bias. The only guideline is the judge is disqualified when a contribution raises a reasonable concern about the fairness or impartiality of the judge toward a party or lawyer. And the judge should consider public perception or the appearance of impropriety. The only specifics within that guideline is that recusal is not required when the donation is $250 or less. Without further instruction, judges have enormous latitude, and attorneys fear retaliation when they risk accusing the judge of the inability to be impartial, especially when there's no specific circumstances for disqualification. The Judicial Code needs broader disclosure provisions to instill public confidence and protect the impartiality of the court. We've discussed transparency, now let's consider accountability. To ensure judges are held accountable, we need to eliminate judicial immunity for malicious and corrupt orders, and enforce the Code of Judicial Conduct with a non-political judicial oversight body. Let's discuss immunity. Currently, judges are immune for malicious and corrupt behavior, even when it violates a constitutional right. This means that a judge can act with the intent to harm and give a false order and still be shielded from civil liability. The problem with absolute immunity is that it creates near absolute power, and absolute power corrupts absolutely. Remember, judges can take our money, our homes, our family, and even our lives. There's a strong argument that judges should be liable for malicious and corrupt behavior that violates civil rights, just like any other individual. Now, don't get me wrong. Immunity from negligence rightly protects courts and judicial independence, but absolute immunity from malice, from malicious and corrupt false orders, causes more harm than good and should be eliminated. Second, strictly enforce the Judicial Code of Conduct with a politically independent oversight body. Currently, the Judicial Code of Conduct isn't strictly enforced. As we discussed in this first video of the three-part series, real governmental power is in political parties and their powerful donors. They control all three branches of government. This neutralizes checks and balances and eliminates protection from separation of powers. Larry Hohol, a litigant in Luzerne County, that's the same county as the Kids for Cash scandal, he gives a perfect example of how the Judicial Conduct Board protects its own. After he was a victim of egregious judicial misconduct, his complaint to the Judicial Conduct Board went ignored. Watch.
I had some very in-depth dealings with the Judicial Conduct Board. I filed a formal complaint with the JCB against Judge Cappellini.
So you take all this evidence to the JCB, and what happened?
I filed a formal complaint, and I met many times with the chief investigator, a guy by the name of Ken Fennell, and he came up and interviewed some people up here and said flat out, he said, I hope this judge doesn't have any plans for his big fat pension. That's a quote, because he's going down. And instead, I got a 2-sentence letter in the mail that my complaint had been investigated and that it had no merit and it was dismissed. But he told me that it was fixed. He told me flat out it was fixed. He said that the judge had contacted the members of the board, told them that he was about to retire, and that they could better spend their efforts and their money from their budget pursuing other activities, as he was going to be out of the picture anyway. And they agreed. Those people need to be investigated, and need to be investigated by a federal grand jury.
After the Kids for Cash scandal, a nonprofit, PA for Modern Courts, investigated the allegations of corruption. Ho Hall explained his research into PA for Modern Courts nonprofit group.
I spent a lot of time with this group. It's called Pennsylvanians for Modern Courts. Look, I contacted these people, and I was very encouraged by who I spoke with. I spoke with very knowledgeable attorneys. Well, they are funded by the government. If they upset the apple cart, their funding will be cut. If they help push the apple cart, wonderful things will happen.
So they're like the fox investigating the hen.
Yes.
Ho Hall's experience, described in his book, The Luzerne County Railroad, illustrates the problem when politicians control the judicial branch of government and protect their own. The only solution is to establish a non-political, independent judicial conduct board. We've been dealing with governmental corruption for so long, we've mistakenly believed that corruption's a reality of life with no hope for improvement. But that's a big lie. We can improve the judicial branch of government by allowing electronic recordings in courtrooms, measuring judicial performance objectively, and providing more predictable guidelines for judicial qualifications from conflicts of interest. These measures will improve transparency in the courthouse. Also, by eliminating judicial immunity for malicious and corrupt orders, and enforcing the Code of Judicial Conduct with a non-political judicial oversight body, we can better ensure judicial accountability. These measures will reform the court system and lessen the Lucifer effect on our country's judges. Zombardo's TED Talk discusses the psychology of evil, but he also includes a positive note at the end, promoting heroism and heroic behavior as the antidote to evil. He proposes that we're all heroes in waiting. His new definition of heroism is ordinary people who do heroic acts or deeds. Former President Obama discusses how an ordinary woman, Rosa Parks, can make a single decision and bring about societal change.
What's remarkable about history is ordinary people doing extraordinary things. Last year Rosa Parks passed away, and I remember sitting on this stage with world leaders and Bill Clinton and senators and governors and thinking we were all paying homage to a seamstress who had transformed the country and helped transform the world. We never know sort of how our actions are going to ripple over time, but each of us can take some responsibility for making sure that we are pushing a little bit in the direction of justice and in the direction of equality and the direction of tolerance. And when we do that, we may surprise ourselves with the amount of influence that in fact we have just by standing up or speaking out.
For instance, Zombardo praises Joe Darby for stopping the Abu Ghraib abuses after he saw the photos taken by the other soldiers. He was just a private, but blew the whistle and then had to go into hiding because people wanted to kill him. Zombardo praises Wesley Autry, a New York subway hero and 55-year-old African-American construction worker who saved a white man who fell into the subway. He jumped on the tracks to save the victim and the train missed him by ½ an inch. He said, "I did what anyone could do." No big deal. Zombardo also praised 9-year-old Lynn Howe for going back into a dangerous building destroyed by an earthquake so he can save his classmates. In explaining his behavior, he said, "I was the hall monitor. It was my job to look after my classmates." Attorneys have also acted heroically by blowing the whistle against judicial corruption, causing them to suffer judicial retaliation by losing their ability to practice law. For example, Richard Fine experienced 18 months of solitary confinement when judges retaliated against him for exposing other judges who received illegal bribes. Leon Koziel wrote a book, scheduled marches, and conducted rallies to protest family court corruption that caused him to lose his law license when judges retaliated against him for speaking out. Susan Settembrino had to give up her law practice to protect her clients from judicial retaliation against her because she blew the whistle and spoke out against court corruption. And she wrote a book, which I read and inspired my video about court corruption. These modern-day heroes are highlighted on this YouTube channel, PA Voter Information Network, under the playlist Court Reform. You see, the same situation that makes people behave badly can also inspire heroic deeds. Most people are guilty of the evil of an action because we're taught, don't get involved, mind your own business. But as Zombardo warns, we have to get involved because our fellow man is our business. To be a hero, Zombardo teaches we have to take action, motivated by helping others, not just our own self-interests. The movement of anti-corruption in politics, court reform, and social justice is truly heroic. And the more people who undertake these causes, the faster change will happen. I hope you like this episode. Please like, follow, subscribe, comment, and forward the video to people on your contact list and social media friends. Signing off. Tune in next time. Bye for now.